November 6, 2012 election. City manager presentation or city attorney?
Thank you, Commissioners. The week before Thanksgiving, we were informed that the city charter referendum, which resulted in the enactment of 4 of the 5 requested changes to the charter, had not been advertised in a newspaper of general circulation in the 3rd and the 5th week prior to the referendum election. We did extensive research on the issue, and I put together a memorandum, which is part of your agenda package, dated November the 13th, 2012, outlining the issue both from a factual standpoint, providing a summary legal analysis, and leaving commissioners with what I believe to be the 3 general options you have to proceed forward at this juncture. We've also provided some additional backup to this, the original charter ordinance 2012-16, the certification of election results. I've also provided, Commissioner, the affidavit of publication concerning the companion bond referendum ordinance, so that you can see what the ad would have looked like had it run in the 3rd and the 5th week prior to the election. And if there was any question at all about whether the ordinance itself, 2012-16, was properly advertised at the time it was enacted, we've also provided that as well for the Commission, just so you can understand and kind of see what the issues are. For the most part, the requirement to advertise in the 3rd and the 5th week is really the only advertising requirement or notice requirement for a city charter referendum. As such, with those ads not taking place, it casts a shadow over the validity of the election of the charter amendments. The courts will, in my opinion, apply a substantial compliance standard to this, and as we see here, since that is the only requirement for notice, is those 2 ads, and neither one of them were placed in a newspaper of general circulation, it makes substantial compliance difficult. There is another concept of what we call substitute notice. That's the general notion that people learn about the election through other means, whether it be the press, whether it be through city publications, the educational brochures and whatnot that were done prior to the election, the state and county election notices that are received, the ballots that are mailed out in advance, the sample ballots that are mailed out in advance by the supervisor of elections. Those types of issues are called substitute notice, and unfortunately they don't always carry the day. So where we end up with basically is that you've got an election that has been certified by the Sarasota County Canvassing Board to you, with 4 of the 5 amendments having passed. It's my opinion that at this juncture you're bound to honor that election until a court of competent jurisdiction, which would be a circuit court here in Sarasota County, states otherwise. Normally in these types of situations, a taxpayer or elector, or voter is another word for elector, in the jurisdiction would file suit to challenge that. At least as of today, I could find no record of any such suit having been filed. Those types of suits are most often found in challenging bond referendums. Those are the most common examples of case law that we have on that. And in all of those cases, the taxpayer and or elector is the plaintiff and the governmental entity is the defendant. But in this case, that hasn't happened yet, so you're kind of left with, what do you do? despite further reflection on my part, I still stand by the notion that option 3 that we've proposed is probably the best one to address the concerns that might be raised concerning the validity of the election. It will place the decision on that into the proper hands, which will be a circuit court judge here in Sarasota County. It would allow the public the opportunity to intervene in that lawsuit if they choose, in order to advocate either for or against the validity of the election based upon the failure to advertise. And ultimately, this commission will receive a judgment of some type from the circuit court that will tell you that either A, your election was valid, or B, it wasn't. And then from there, this commission can take the appropriate action it deems concerning the election based on that judgment. Taking no action is an option, and I bring that up because, as I said, I could not find an example of where the government, went to court and said, "Oh, by the way, we made this error. What do we do about it?" It seems to me that the electors / taxpayers of the jurisdiction are the ones that usually bring these suits, and that brings the issue in front of the court for determination. The city's named and/or county or whatever governmental entity is involved is named as a party. They have an opportunity to participate. So this is just sort of the reverse of doing it, and I'm happy to answer any questions that you might have relative to this issue.
Commissioner Blucher?
Yeah, it sounds like we're stuck between a rock and a hard place. But on option 3, as our city attorney, can you give this commission any idea of cost?
Yes, sir. The filing fee for a circuit civil suit in Sarasota County is $400. It's an extra $1 if you get a copy of the complaint certified back sent to you. So usually it's $401. By comparison, the bond, well, it wasn't bond. We called it a debt validation proceeding that we did for the B loan. That ran us, and that was uncontested. No one fought to challenge that. That ran about $15,000. So I would say, probably by analogy, similarly, if it's uncontested, you're probably looking at somewhere between 15 and 20. If it is contested, it would be more than that, because there very well might be some discovery and some other things that the taxpayers might want to do in regard to that. In all likelihood, it's a legal issue for the court to determine. The facts, I think, are relatively straightforward. The only other issues would be the act of proving up some of the substitute notice, some of the other things that happened that would have alerted taxpayers. There's a taxpayer standing issue here too. Typically, the courts have ruled that if the taxpayer had notice of this issue prior to the election, they don't have standing to challenge it. So that will be a requirement for a taxpayer to show that they did not have notice. And what I mean by notice is notice of the defect. If a taxpayer knew the ads weren't run, then they're not going to be able to challenge it. And it may also be that, taxpayers who voted may have some standing issues as well, but we didn't really look too deep into that, to be honest with you. I think the notion that I would propose to you is not to fight too much over the intervener issue. If a taxpayer wants to get involved, and as long as they didn't have notice of the defect and didn't raise it to anyone, that they be allowed to liberally participate on either side of the equation, either way.
Commissioner Jones?
Thank you, Mayor. City Attorney, I don't know if this is really your question or not, but I was under the impression that there was an attempt made to advertise this ordinance. Was there any attempt made to advertise this ordinance? What was advertised? You said you were informed it wasn't properly advertised. Was it advertised?
Well, no. I mean, it wasn't advertised at all. I mean, that's what I was informed of. Thursday was a week ago. I don't. Well, as I indicated to you, and I've attached, there was an ad run when the ordinance was initially enacted. Okay, that's the ad that's required anytime you enact an ordinance. If you read the ordinance itself in the statute that I've given you, there's a separate requirement to advertise the referendum election in a newspaper of general circulation within your jurisdiction in the 3rd and 5th week prior to the election. The body of the ad is in the ordinance. It's in section 6.01, so that you can see what the ad looks like. And if you're curious, I've given you an example of what that ad would look like because we ran one, the clerk's office ran one simultaneously for Ordinance 2012-15, which was the bond referendum. So the city was in essence calling for 2 separate referendum elections. One was for the bond and one was for the charter amendments. And the one for the bond was advertised in accordance, the referendum was advertised in accordance with the statute, so you can see what that looks like. But the one for the charter was not. So I apologize if I misspoke. That no ad was run is not that a defective ad was run, but you know, from a legal standpoint, we would say the notice is defective because no ad was run.
Thank you.
City Attorney, so you've given an idea of about 15 to 20,000 as far as anticipated if it's not challenged or somebody if somebody doesn't add to it and intervene. And I had asked other questions as well prior to this meeting, and I never did get a response to that.
Well, we got the cost for you.
Okay.
And the only other question that I was aware of was the you had a question about one of the specific questions and whether the ballot summary question matched the actual ordinance that was passed. We were given that question, I think, the day before this one came up. But my view is that, you know, we need to address the bigger picture of whether the entire election was valid or not. Defects in the ballot summary are not fatal. The law is relatively clear on that. You can have typos. The summary is just that in and of itself, a summary. And what matters is the ordinance. And there's a reason that the ordinance is posted at and is required by statute to be posted at all the polling jurisdictions, so that if any taxpayer who's there voting has any question about it, they can go over. I didn't personally verify that the supervisor of elections did that, but that's what they're supposed to do. They're supposed to post the ordinance. So a defect in the question, and I think in this case it was omitted 2 words before. It was the question on district residency. The words that were omitted, I think, were before 2016. That's not defective notice. That's not defective to the election, and that's what the case law says. Now, we didn't take that issue and run with it to do additional research because this one came up the next day, and quite frankly, if the court decides the election's invalid, it doesn't matter what the ballot summary said. And since it's not a defective issue for notice, I don't think I would muddy the water with the lawsuit that we have. We need to get the court to focus on whether the electors in Northport had valid notice of the election in general as it relates to the charter amendment. I'd like to think most voters knew there was an election if they voted, and that there were a variety of things they were going to be asked to vote on, everything from president all the way down to city commissioners. But the question will be, you know, were there voters who were disenfranchised, did not vote because those ads weren't run? Did they not? Would they have gone to the polls and voted had they seen that ad relative to those ads? There would have been 2 of them concerning the charter referendum, and that's really what you want the circuit court to focus on.
Okay. So, yeah, my question did actually involve whether or not, since we are aware of the error with regard to the districting question not matching exactly what's in the ordinance, which is the way it's prescribed in the statute, that it must be incorporated in the ordinance, whether or not to join in with regard to, if we are going to move forward and ask a judge to rule on this, that you kind of know that there's two errors that were made. Why would you not kind of get the opinion at the same time if you're spending the money to go do it? Is it possible to just be able to do that all at once instead of having to readdress it or leave it out there? And if we want to really clear any cloud with what we know as a city as to the things that had been done or the errors that had been made, would we not want to go ahead and put that in there?
As I've indicated, an error in the ballot summary is not fatal to the election. So I don't know what it is I would tell the court. I mean, I would be asking him to tell me it's not fatal when I know it's not fatal. We have, the case law is relatively replete with examples of ballot summaries, and then the only one that I found in doing the research on the larger issue was where Sarasota County actually did not do any ballot summary. And under that circumstance, the court invalidated the election because there was a failure to comply with the statute. But what the courts say is that the ballot summary is just to inform the public in summary fashion of what's on the election. And it should trigger either an obligation or a desire to dig deeper, and that's where the posting of the ordinance, which is, because that's what actually changes the charter. Your ballot question, you're limited to 75 words. Most of our,
Yeah,
you want to interrupt me, go right ahead.
Well, I understand it because you've explained this before, and I guess what I'm trying to get to is, can we go ahead and ask that question? I have not received any legal opinion, and actually, based on the charter, the only one that can judge this is a judge. So, if we know we made an error, I'm just saying that why wouldn't we? We could, but you're not recommending.
You could. I wouldn't. I mean, my concern is always, what we're going to spend in legal fees, and that's certainly going to add to it. If it's a question that we already kind of know the answer to, and like I said, isn't fatal to the election, it's happened in Northport before, where the summary on the ballot was winds up. I think we had an error in the ordinance with the order of who was going to be chair and vice chair, and we determined that wasn't fatal to the implementation of that provision in the charter. So we can ask the court. I think we know the answer. If the commission would feel better about just having a court bless that issue. But I just didn't want the court to lose focus on our main issue, which is the validity of the entire election. And it very well may be the court determines not to rule on the smaller issue, on the what we call the doctrine of mootness, having ruled on the larger issue. But it's up to commission. It's just a function of resources and kind of knowing where our bigger problem is versus that one.
Okay. Can you send me the information on that? Because I did ask this question a couple of weeks ago. I have gotten nothing in a response in an email with regard to the districting question. I have not gotten the legal opinion. I have not gotten anything that said this is a non-fatal thing, because basically then, I mean, I've asked you these questions because I have not heard of anything, and I have nothing.
The first time I saw that was this weekend. As far as you asking me specifically about this issue, we had a conversation on the phone with the clerk's office about the larger issue, I thought, which was is the election void. And because of the severity of that issue, that's where we put our resources really nonstop from Thursday before Thanksgiving up until I transmitted the memo to the commission. I think about 3:30 Wednesday before Thanksgiving. And as I said, that's the issue I think I'd like commission to focus on, because it invalidates the issue with the mayor, it invalidates the district residency, it invalidates two other important charter changes as well, and we need an answer, would like to get an answer from the court as soon as we can on that issue, because you're living up to the elector right now by implementing those charter changes, but with that cloud hanging over, those changes.
Right. And I do understand the bigger issue with the big cloud getting decided upon, which it could be upheld and stick. And then if it does stick, then we still have a little cloud under here, and that was my only point. But again, I did brought the question to city clerk, and you've known about that actually since right the 13th or something.
The clerk's office, they called me in on Thursday morning. I was at P&Z. Patsy and Helen met with me. They told me about it, and the very next day I got the call about the bigger questions. So, with resources what they are, we devoted them to the bigger question, which I was told needed to be on this agenda tonight, which is the question of the validity of the charter referendum. It's not that we're not going to pay attention to the other issue. It's just, to me, that one trumps the other one, and at an appropriate time, if it's now, that's fine. We can put that in writing as well. But as I said, my opinion is, based on the research that I found while doing the research on the bigger issue, was that ballot summary errors are not fatal. So it's not fatal, then that's really my concern, is the election valid or not? But if the commission wants it added, we'll add it. It makes the complaint longer, and the time we spend with the judge a little bit longer to go through those issues, and I feel more confident about that issue than I do the other one. But we certainly can add it if that's the desire of the commission.
Yeah, I'm not debating with you as to whether or not to add it. I'm asking you, can you please send that to me in writing? Because I did bring the little question to you. I brought you the bigger question.
We will put that in writing to the commission.
Thank you. Commissioner Jones.
City Attorney, I didn't ask this question before because it just not the biggest issue, but you have addressed the issue of time, and I know you don't have a crystal ball, but if we did select option 3, do you have an idea? Is there any precedence about how long it takes to get back an opinion about it like this?
I would say 90 to 180 days. And I say that because we have the experience of the recent filing for the SIB. I know how long that took, and unfortunately, we are going to lose some time because of the holidays in the month of December. It makes it more difficult to get a hearing in front of the judge. You also have to give a reasonable opportunity for the electors to. What we would typically do in that situation is, I'm not suing anybody in particular. I'm just basically naming the electors of the city of Northport as a defendant in the lawsuit. And what I would do then is I would actually advertise the lawsuit in a newspaper of general circulation in Sarasota County to give the electors the most opportunity to participate. And then you give them a reasonable time, Commissioner Jones, to reply, usually 20 to 30 days after they've had a chance to see the ad.
I understand, and I thank you for your attempt to put a time frame on it. I realize it's not easy, really difficult, but thank you.
City Attorney, did you also get an answer to the question with regard to the fact of whether or not it is required for publishing the date of the county certification of the municipality's results? In researching that question that had been asked, as the time frame changed from the 19th to our meeting having to be on the 14th, all of that happened because we got the results early, and then apparently this election and the last election, we got them very early. However, in the past, in 2008, 2006, it's always been the date after the published notice of the certification and the canvassing. So have you kind of...
I think it's relatively clear that, the certification occurs at the leisure of the canvassing board at such time as they are done with their duties. Hindsight's 20/20. But we were told, clerk clerk's office, my office, was told that it was going to happen after 5 p.m. on November the 16th. And so from that point forward, by looking at our charter and what our requirements were for, we moved to proceed with the with the swearing in on the 19th. I don't see anything in there that provides or vests any jurisdiction with the city to intervene in the canvassing board's duties and responsibilities. You could make a good argument that somebody should have picked up the phone and called us, but that's not in and of itself a violation of any laws that I'm aware of. And I think, next go around, what it entails is probably, some closer line of communication with the supervisor of elections, so we know if she's going to do that prematurely. My guess is her schedule was based upon the length of time it normally takes to certify a presidential election, which is give or take about a week. And, in this case, she managed to do it in 4 days, 3.5 really, if you count the election being over Tuesday at midnight, and she certified them at 3:30 on Friday afternoon, 3 days later. But as far as a violation of the law, no, ma'am, I don't see any violation of any law relative to their duties. They get them certified when they're certified, and then they send them out to all the jurisdictions that are affected, and maybe next time we can work more closely with them to assure that happens on a specific date and helps us plan better.
So they don't legally have to publish a notice of that certification?
Well, my understanding, there was a question asked by somebody about whether the canvassing board meetings were public meetings, and the response I saw from the supervisor of elections was that they were, and that those meetings were noticed in a newspaper at some point in time in the past pursuant to the statute. That's all I saw. So in other words, the meeting of Mrs. Dent and former Judge Legalbo and Judge remember the other one? Judge Dinkin, I think, was the other. That meeting, whenever that took place, was noticed according to the supervisor of elections in a newspaper of general circulation prior to the election, in accordance with the statute, and that's all I saw on the issue.
This is public comment.
All right, I have one public comment. Michelle Martin.
Hi, thank you, Mayor and Commission. Michelle Martin, Northport Estates, for the record. I had a few different things to say, and I just want to make it really brief. I know we are running very late tonight. I think that it is important that we make sure that the integrity of our election is upheld, and as much as I may not like the results of the questions and how the vote turned out, I do tend to agree with Attorney Robinson that we need some kind of final judgment on the matter. We need the answer to come from a judge so that it can't be challenged in the future, whether or not these results should be able to stand. I don't think basing whether an election is valid or not should be based on any kind of speculation. So that would be what I would say about that. I just heard City Attorney Robinson talking about the early certification, and that is the main crux of what I want to talk about tonight. The statement was that we believe that the early certification of our local votes, or the certification of our votes, takes place at the leisure of the canvassing board, and that they're not at all held to any kind of public noticing of when they're going to certify those results. I find that very difficult to believe because, as some people may or may not know, there is a 10-day deadline attached to the date of the certification of election results, a 10-day deadline for me as a resident of Northport, or any resident of Northport, to exercise their statutory right to challenge the results based on filing through the clerk of court, I believe, through Karen Rushing. There's a 10-day deadline attached to that. So if I was looking at the Sarasota County Board's website and I was noticing that it says final canvassing and certification to take place on the 19th, I assume, or on the 16th, I assume I have 10 days from that date. Had I not been at that meeting to watch the swearing in of the commission, or excuse me, the meeting before that, the lame duck meeting, and heard at that meeting that the election results had been certified Friday and that the meeting to move up, the swearing in election, was moved up to the 14th, I would have assumed that it wasn't going to happen until the 19th. My 10-day deadline ended on the 19th. When would I have been told that my right to file a contest of election, when would I have been told that my 10-day deadline started 10 days early? I think that's very much a city issue. And I find it difficult to believe that there isn't some sort of law or guideline or statute set forth to tell the SOE when she can and cannot do those things. Thank you.
I have no other public comment cards. Commission.
I'll try to move for option number, to approve option number 3.
Second.
I have a motion by Commissioner Blucher to approve option number 3, seconded by Commissioner Jones.
Yeah, I really don't like it, but I don't think we have any other choices. The city attorney did give us some options, but I can't go with either one of those first two. So I think the third option is where we have to go.
Thank you, Mayor. The option to go with the filing the suit for declaratory judgment is probably the best thing for this city. Always, whenever we make our decisions on what's good for our citizens and what's good for our city. And although sometimes they're tough, and this one's tough, I still think that this is the best option. In my mind, we certainly had a valid election. Our voters certainly went out there and cast earnest and intelligent votes, and no one was unaware of the election or the issues in the election. They approved some issues. They disapproved others. They gave us a mayor. They approved districts, which I never approved, but I suggested the mayor, and they did that. So they didn't just vote one way, is what I'm trying to say. They voted what they thought was right, and certainly that means that they cast an intelligent vote. So I kind of lean towards really not doing anything, because we did have a valid election. I'm sure of it. But what's good for the city, what's good for our citizens, is to get this declaratory judgment and get this thing put aside, put it to bed. Now, that's why I seconded the motion.
It's kind of such a interesting situation. The election, we had many of the questions that had substantial differences in the votes between them, and it was clear the decision of the citizens. We all have our own opinions up here about how we felt and didn't, what we may have liked and not liked. And I think, the decision to bring this to a judge, which is an unbiased entity and somebody that can take a look at this, makes the best sense to protect everybody. Those that supported it, those that didn't support it, to make sure that the integrity of our charter is really something that we can't take lightly and don't ever want to have any shadows cast upon it. And hearing the citizens talk about some concerns about what had happened and that they had come to find, and certainly then deciding to bring this, as soon as I found out, to the city clerk and get working on, what do we do now, and had never been really had a situation such as that to find out that we ourselves as a city had made an error. In certainly no intent in that. It just as an oversight. I do believe that since we do know that there is, another material cloud, albeit maybe it's small, but we do know about it. And if we're going through the process, I just would seriously consider that we might as well tell them everything, put it in there. And if one portion of it, let's say the notice is not enough to make the whole thing fail and null and void the election, and it's upheld, well, then we can have the other question answered, and it relieves any slightest bit of doubt of anything. I don't have any other information to go by what's been verbally said up here. And again, relying upon the charter that when there is a question, besides the commission, the next person is a judge, and only a judge that can make that decision, not an AGO opinion, not other opinions that may be out there. So I don't think it would hurt to include the ballot language in one of the amendments that was in error. So if somebody would want to amend that motion to include that, I definitely think it may be in the best interest to tackle all of the issues and get it out there.
Yeah, I'm happy to include it. I don't think you have to amend the motion. I mean, it's just being prudent. We can just add it in there. It's not a big deal.
Okay.
Okay, never mind.
Yeah. It's money. It's money.
Did you have a comment? Oh, okay. So that being it, we'll call the vote. And that is 4-1 with Commissioner Yates dissenting, and only dissenting for the reasons that I feel all errors we're going through the process. And so potentially now, it's an error that was made and certainly could cost us money just by somebody possibly feeling that it's something that they should pursue individually, and then costing us more money in the end by having to battle that. So that was my reason for dissenting on that.
Mayor, could I have a short break?
Break?
Short break.
All right. We will take a 5-minute break.
Thank you.
Yeah, we get down those steps.
Okay. All right. The next item on the agenda, Commission, is item D, and this is discussion and possible action regarding the adoption of the 2013 meeting schedule for districts and commission meetings. Do I have a presentation?
I don't know that I would call it a presentation, but certainly not at this hour.